You're listening to the Quint's podcast.
कोई अगर कंप्लेन कर रहा है तो उसकी कंप्लेन पे तो ध्यान दो। तो सर कहते हैं कि आपको नहीं करना है मत करो, ठीक है, पर आप इस तरीके से गलत फहमी मत डालो लड़कियों में।
The person you just heard is Gunjan Chaudhary. We changed her name to protect her identity in this podcast. Gunjan is one of the over 50 female partners working with the home services company Urban Company, who camped outside the company's Gurgaon office on 22nd December, demanding better pay, safer working conditions, and social security. However, the company responded to this protest by filing a lawsuit against these women for their quote-unquote illegal protest. But the issue of compensation, working conditions, and social welfare is not isolated to one company or one protest, but it's about the working conditions within the gig economy itself. This sector is booming in India, with a report by ASSOCHAM, which is a non-governmental trade association and advocacy group, stating that over 130 million people are working for these platforms, and that this industry will grow to $455 billion by 2024. And with the pandemic crippling the economy and companies trimming their staff, many more have turned to the gig economy as a source of employment, where these platforms promise quote-unquote flexibility as opposed to traditional work systems. But there is a dangerous flip side to working in this sector, with non-existent social security, complete lack of benefits as compared to a traditional workforce. So with millions of workers employed in this sector, how are these constraints affecting them? And is this gig economy creating a scope for labor exploitation? To get an understanding of the ground reality and the problems gig workers face, we spoke to Gunjan about why Urban Company workers had to resort to a protest against the company. You will also hear from Rajendra Chadda, a former spa therapist working for the Urban Company. We also spoke to Mr. Sheikh Salahuddin, the National General Secretary of the Indian Federation of App-Based Transport Workers, IFAT, Shahana Bhattacharya and Archana Agarwal, members of the People's Union for Democratic Rights, an independent organization which defends civil liberties and democratic rights, and Vakasha Sasdev, the Quint's legal editor, to understand how this economy functions and its restrictions. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. Let's start first with the protest that was held in Gurgaon by dozens of female gig workers with Urban Company. These workers, or quote-unquote partners, as they are called by Urban Company, started protesting in October this year, where they held a day-long strike, during which they alleged that the company has been incrementally hiking commissions, which is cutting the partners' payout. The women protesters, comprising mostly of beauticians and spa professionals, have demanded safer working conditions, better payments, and social security. And these demands were taken to the company as well, but according to Gunjan, one of the protesters we spoke to, they received no response from the company and had to resort camping outside the company's offices to get one. According to Gunjan, when she and the others approached Urban Company with their concerns, the company bluntly told them that if they are not comfortable, they can refuse to work.
शुरू करने से पहले हम 4-5 लड़कियां मिलने गए थे सर से, जनरल मैनेजर सर से मिलने गए थे कि जब आपने लड़कियों को फ्लेक्सी में डाल दिया, हम फ्लेक्सी के ऊपर ही बात करने गए थे कि सर फ्लेक्सी जो है कोई भी एग्री नहीं है और लड़कियों के पास काम नहीं आ रहा तो बहुत मुश्किल हो जाएगा। तो हम इसी बारे में बात करने गए थे, मैं, सीमा जी और 2-4 लड़कियां और थी। तो उन्होंने बोला कि आप इस चीज को थोड़ा सा समझो, हम आप ही के लिए ये सब कर रहे हैं। तो हमने एक बात रखी थी कि ठीक है सर, हमारे लिए हो रहा है, आप ठीक है, कंपनी को रन करना है तो कुछ ना कुछ तो आगे थोड़ा सा लागू करना ही पड़ेगा, जो लड़कियां काम नहीं उठाती हैं। लेकिन कोई अगर कंप्लेन कर रहा है तो उसकी कंप्लेन पे तो ध्यान दो। तो सर कहते हैं कि आपको नहीं करना है मत करो, ठीक है, पर आप इस तरीके से गलत फहमी मत डालो लड़कियों में। तो हमारी बात इतनी थी कि सर फ्लेक्सी को थोड़ा सा तो कन्वीनियंट करो, लड़कियों को काम तो दो। लड़कियां ऐसे बिल्कुल रोड पे आ जाएंगी अगर फ्लेक्सी में आपने फ्राइडे सैटरडे संडे भी काम नहीं दिया है, वो कैसे अपना रिस्पॉन्स रेट अच्छा करेंगी फिर। तो सर ने बोला कि देखो इस पे तो अभी हम बात कर रहे हैं, आप बिना वजह लड़कियों को भड़का रही हो। उन्होंने कोई सोल्यूशन नहीं दिया, बल्कि उल्टा हम पे ये बोल दिया कि आप भड़का रहे हो, कोई प्रॉब्लम नहीं है इस चीज में, आप जबरदस्ती की बातें कर रहे हो।
How the protest came under the radar is because in a first, a lawsuit has been filed by Urban Company against the women partners protesting. The company has sought an injunction from the court directing the police to make arrangements and disperse the protesters. And according to Gunjan, the company was not receptive to their demands during the protests as well. She adds that the company shut off its main gate, did not allow access to washrooms, and even turned off the street lights.
उन्होंने लाइट ऑफ कर दी थी, वॉशरूम यूज नहीं करने दिया हम बल्कि
They had let us use the washroom during the daylight on the first day, but at night they turned off all the lights, including the street lights. They did not let us use the washroom. We even informed them that some of the women are pregnant, and even then they didn't budge.
ठीक, वॉशरूम इन्होंने यूज नहीं करने दिया. हमने इनको बोला भी कि लड़कियां प्रेग्नेंट हैं, प्रेग्नेंट को तो जाने दो कम से कम.
As I said earlier, this is not an isolated incident, nor is this the first time gig workers have protested. In fact, in Hyderabad in September 2020, over 3,000 Swiggy delivery executives logged off the app in protest and demanded better payments and commissions. But why do these protests keep resurfacing? The answer lies in the way the contracts are structured with the platforms. Food delivery platforms like Swiggy or Zomato, or travel platforms like Ola and Uber, all around the world define their workers as contractual employees or freelancers and not as permanent employees. These companies argue that they are not an employer, but a quote unquote internet service or a quote unquote broker, which merely seeks to connect the customer, the business or service, and the delivery partner. Vakasha Sachdev, the Quint's legal editor, explains that this argument and the use of this terminology is an easy way out for these platforms to avoid giving any or little employment benefits or no fixed salary.
There's a very clever thing done by the companies where they say they're partners, they're delivery partners, they're service partners, they're executives. They use all these terms rather than saying employee or worker. Now, when you listen to what their argument is, they say, oh, look, we're trying to, we're giving them flexibility. They don't have to work for only us, they can work for someone else. They get to choose which things they work on. They get to choose their timings. They get to choose. This whole argument is made that look, we use this terminology. We use this term partner or executive or these kind of things rather than employer worker because they really aren't workers or employees. That they are actually to be viewed as partners and executives because they are being given choices. They are being given the ability to work in a way which doesn't fit within an employer-employee relationship or the relationship of workers, at a factory, wage workers or someone of that sort. Now, this is, I mean, how does one put this politely? It's pretty it's nonsensical. I mean, there are the words we could use for it, but it really is because look, I mean, it's easy to try and believe this language when you see it on paper, but I think there's mounting evidence from around the world that that's really not the case. And this is something which has been now expressly recognized by courts in the UK and in France, which have held that Uber drivers are not to be considered as just workers or are not to be considered as being just these whatever magical contractual partners. There is a worker relationship. There is an employer-employee relationship in many circumstances. Now this is because of the nature of the way the work goes. Because if you look at the concept of what is an employer, what who should you be considering an employer and who should be considering a contractual person is there. It's about control over execution of work. Is it about who has the power to dismiss, to appoint, to make changes to the way you are paid in terms of what your daily tasks are? Now these are all things which determine what is actually an employer-employee relationship. Otherwise, potentially you could have a situation where someone could be doing all of this, where they run literally your whole life, all your work, and just say, oh, you're not an employee because that's just the way the contract is done. That's not quite how it works. And the thing is that the Supreme Court has actually dealt with this issue before not in the context of gig workers, but in the context of workers where it's been held that there is genuinely an employer-employee relationship because of the way in which their relationship works. So no matter what it says on paper, in truth, it really works like an employer-employee relationship, and that's what sort of gig workers are trying to argue now, and it is something which you'd have to suggest is very much the case. I mean, you look at whether it's Swiggy and Uber workers who, sure, they potentially can do both, but each of them is setting clear targets for them. The way they have to, earn their money is based all of that on that. The amount of money, the remuneration is all set by Swiggy or Zomato. And look, the thing is, you can, as I said, you can say that look, you can do multiple things here, but at the same time, the way the incentives are structured, the way once they've signed the contract, they then are constantly forced into updation of terms, into doing things differently, and suddenly in terms of where they'll be assigned to work, how far they have to travel to work. All of these things are purely at the discretion of the company. And the thing is, you can say that yes, they could always just leave it at any point of time, but I think that's a very uncharitable way to look at all of this, and it really actually doesn't stand up to legal scrutiny, because the courts have said that in the past, we've seen in India as well, that this kind of that just because you are giving potentially the freedom to walk away from a contract as well, doesn't mean that that becomes now. Of course, this is still not quite, as we said, been held in cases relating to gig workers. But you can see the argument here for what the gig workers are saying. You can see why, of course, the contractual arrangements are made as they are, is because they allow companies to make these arguments, to say we don't have to pay insurance, we don't have to pay overtime, we don't have to allow you leave, we don't have to make arrangements for you to to actually have the things you need to do your job. Like if you see, for instance, they make them buy their own uniforms from them. They don't give them any help with getting their mobile phones or anything at the start. They're forced to take loans from these companies for various things. I mean, it's there's just so much of this stuff which is all the language of exploitation which comes up in a system which relies on private enterprise. Which, look, at the end of this is not saying that private enterprise or capitalism itself is terrible and inevitably going to lead to this, but there's a reason why you have regulations for employment for workers in even in societies which have capitalism, which function there. There are regulations, there are labor laws there, because there is always the scope of exploitation. And the point is, you're supposed to be able to prevent that. The problem is that the way these contracts are structured takes these workers away from any scope of protection.
But you may be asking how these companies provide their services at such affordable prices. That is due to how this entire gig economy business model works. The basic premise is that these platforms depend on a large pool of workers who are willing to compete with each other even at low wages. And a low wage worker equals to a low cost service, meaning that you as a customer are offered steep discounts at breakneck delivery times. And it's often the worker who gets exploited in the process with long working hours and insufficient income. People's Union for Democratic Rights, or PUDR, an independent organization which defends civil liberties and democratic rights, in a recent report investigated the issues that affect gig workers and found that though there is no traditional employer-employee relationship, these platforms have a lot of control over these gig workers in terms of how many times they can refuse service, to the number of required orders they have to make, to even the products that they use during a service. Shahana Bhattacharya and Archana Agarwal from PUDR, who wrote the report, explain more.
What we have found is in Uber and Ola, by about 2017, the incentives are reduced. So you basically, what the urban company issue now is also that you have to do so many rides to actually get the incentive, right? And in this case, so basically that when we're saying that the lack of freedom, so you are supposed to be flexible, but you are tightly controlled actually. So you have to do that much more work, or you have to do a minimum of these many orders to actually get sort of incentives. And since this has become the primary income for most of these workers, it's not actually a choice anymore. So
So the moment, for instance, a Uber driver would log in, the moment he logs in, even before he logs in. So once he has to register, it means that he has to obviously provide his personal details and various kinds of documentation. Then the moment he logs in, from that moment, the number of rides, the fare he charges, where he goes. I think both I and you are familiar with this idea that when we ask for an Uber driver, he will often ask us, where do you have to go? Because he does not know until he's spoken to the customer. He has no choice of saying that, okay, I want to go there and I don't want to go there. He just knows that there is a ride which is coming. I mean, there is a demand that is there, order that is there. So from where he has to go, how many rides he must do, how much waiting time is there between the orders, between the next order, which will be unpaid waiting time because nobody is going to pay him for that. What is the fare that will be charged from the customer? Now, at the time when he wants to log off, so has he done the requisite number of trips? And if he refuses, like again, this is something which would be familiar to us. Often the drivers would say, "Aap cancel kar dijiye, hum cancel nahi karenge." So the reason for that is because, I mean, there is a show of them being completely free. But the fact is that if they do too many cancellations or too many refusals, then the refusal kind of becomes a black mark against them, and in extreme cases could lead to deactivation. So if they're deactivated from the app, this is similar to termination in a normal employer-employee world.
And Gunjan Chaudhary, who works as a beautician with Urban Company, further provides evidence to this. She believes that most people join these platforms under the pretext of it being quote-unquote flexible, and that in the initial few months of joining the platform, she received a lot of assignments from the company, but alleged that these jobs started declining after a few months when the loan they had taken from the company to buy the products that they used during a service was paid off.
जो स्टार्टिंग में आपको जैसे आप रिसेंट आपको ट्रेनिंग देने के बाद में लाइव किया जाता है तो आपको 1-2 महीने पता समझ ही नहीं आता है कि कितना क्या कट रहा है या फिर हमें क्या बेनिफिट हो रहे हैं, क्योंकि कुछ लड़कियां जब काम स्टार्ट करती हैं तो कंपनी में जो हमें प्रोडक्ट दिया जाता है वो लोन पर भी दिया जाता है, जो हमारी किट बनती है वो लोन पर भी बनती है, तो जब तक हमारा वो अमाउंट नहीं करता तो काम अच्छा आता है, तो लगता है अर्निंग हो रही है कि हम चाहे ऑनलाइन पेमेंट आए चाहे कैश आए तो उस टाइम पे लगता है कि काम आ रहा है, अच्छा काम आ रहा है, तो भाई ठीक है, अच्छी बात है.
In the initial months, there's no clarity on how much you are earning or how much payment is being cut. When we start, we take the products on a loan from the company. Till the time the loan amount does not get cut, the assignments come regularly and it feels like we are making a good income. But after a year, you start to understand the challenges and risks involved. The more the earning you have, the greater the risks there is. We only had one demand from the company, which was to increase our assignments. But what the company is doing is that they are hiring new workers and giving them good jobs and sidelining us. And the cycle goes on and on. The work starts noticeably reducing after the loan amount is paid back. You start getting work outside your zone, which may be 15 to 16 kilometers away from the location. And if that job is not very well paying, then with the money spent in travel, we have negligible savings.
15-16-17 किलोमीटर जाना पड़ेगा, अगर हमें 5 से 10 किलोमीटर के अंदर की कोई लीड आती है तो ठीक है, 5 से 17 किलोमीटर की अगर हमारे पास लीड आएगी और वो छोटा पैकेज होगा लाइक 500-700 का होगा तो उसमें हम क्या बचाएंगे, आने जाने में ही सब कुछ खर्च हो जाता है हमारा.
Rajendra Chadda, a former spa therapist with Urban Company, echoes Gunjan's claims and adds that buying the kit from the company is compulsory and cost about ₹25,000, but that its real value is nowhere close to it.
जैसे अब नई ज्वाइनिंग कर रहे हैं ना सर, तो हमारे टाइम में 25,000 की किट थी, अब पता ही 35 या 45,000 की आज की डेट में किट है. ठीक है, कंपलसरी आपको लेनी पड़ेगी, उसी के लिए लोन होता है सर. फर्स्ट टाइम बेड होता है, उसमें मसाज बेड वगैरह और चीजें देते हैं. और रियल वैल्यू
When you are a new worker, you have to purchase a kit from the company, which is sold to us for 25,000 rupees, but the real value is not even half of that. It's only worth about 5 to 6,000 rupees. This way they make a lot of money just by this, by hiring more employees and then blocking the IDs of the existing ones. And this cycle keeps going on and on.
अगर ये आपको 20,000 का सामान दे रहे हैं तो वो मुश्किल से 4 या 5,000 का सामान भी नहीं होता है.
We got in touch with Urban Company for a comment as well, but received no response. And for the past few months, gig workers have legally challenged their status as freelancers and have demanded to be classified as workers, which will allow them minimal protection under the labor laws. However, just bringing these platforms to discuss the concerns, even at a union level, is proving to be very difficult. Mr. Shaikh Salahuddin, who is the National General Secretary of the Indian Federation of App-Based Transport Workers, or IFAT, claims that he and other union reps sought meetings with platforms like Uber or Swiggy on multiple locations in different cities, but the company's representatives regularly evaded these meetings or never showed up for them.
हम इधर गवर्नमेंट को इधर कंपनीज को नंबर ऑफ टाइम्स हम रिप्रेजेंटेशन दिए, चाहे मेल में हो चाहे फिजिकली उनके लोकल के जो भी मैनेजर्स है, मगर अभी तक कोई भी चीज वहां पे से आउटकम नहीं आई.
We've approached the government and these platforms multiple times at all levels of management, but there has been no outcomes from this. Companies refuse to talk to us and even the government officials. These companies will first acknowledge the meeting and that they'll come back with a response after speaking to the higher ups, but they'll never show up. And this is not just one state or one ministry or one incident, whether it is the labor ministry or transport in any state. These platforms have never created an atmosphere to speak to labor unions or hear our concerns.
कंटिन्यू मीटिंग में वो कल आएंगे नहीं, वो जवाब देंगे नहीं, क्योंकि ये आज एक दिन नहीं हुआ. ऐसे बहुत सारे स्टेट्स के अंदर बहुत सारे मीटिंग्स वहां पे जहाँ पे जब गवर्नमेंट बैठ के बातचीत कर रही थी, चाहे वो लेबर मिनिस्ट्री हो, चाहे वो ट्रांसपोर्ट हो, चाहे वो IT हो, ठीक है ना, चाहे वो IAS IPS का लेवल कैटेगरी हो, कहीं पे भी इन लोग ने, कंपनी ने बैठ के बातचीत करने का माहौल भी क्रिएट नहीं किया गवर्नमेंट से भी.
And this lack of response from the platforms led to the union to approach the Supreme Court. In their PIL filed in September 2021, the union claimed that the fundamental rights to equality and life and right against forced labor of gig workers has been violated. They also demanded that gig workers should be considered as quote-unquote unorganized or wage workers under the existing laws. And this type of legal intervention follows the footsteps of similar attempts worldwide, where courts around the world have adjudicated these claims of gig workers. But will an Indian court follow the same route? Do our laws and provisions also allow for gig workers to be considered as wage or unorganized workers? According to Vakasha, it is difficult to say on how the evidential process will be proceeded in court, but that there are very strong arguments to be made to give gig workers recognition given the control platforms have on their work.
Now, they're saying that one, they should be recognized as, there should be a recognition of this as an employer-employee relationship, which itself, which is one argument, as we said, which can work in terms of looking at some of these previous Supreme Court judgments, but that may not necessarily, entirely work, because if the court finds that there isn't a sufficiently high degree of control over the way they function, then that wouldn't necessarily mean they could be called employees. But in terms of being considered sort of workers in the unorganized sector, that is something which actually could still happen, and that's a key argument being made here. Is that there is an Unorganized Workers Social Security Act of 2008, which says that the central government is to provide social security schemes for unorganized workers. And what they've argued is that currently there is a lack of recognition of them even within this framework. So it's not just this is not just about the way the private companies are dealing with this. It's also about the way the government is failing to recognize these workers in particular ways. There's a strong argument which which will be interesting to see how this works, though it's difficult to see where how the evidentiary process will go at the Supreme Court itself. Is there's also an argument that the denial of the social security, the way they're being forced to work, can actually be considered as amounting to forced labor under Article 23 of the Constitution. Now, given the sort of control over minimum hours of work, the way the work has to actually be carried out, this is an argument which can be. It's an interesting one, but of course, it's something which you may not really see the courts accept. But you never know, because these contracts, again, remember, there's no negotiation. It's pretty much unilateral from what the company says. Basically, at the end of the day, this case is not gonna. We don't know the outcome at this point itself. There are strong arguments. There is some amount of now legal precedent, both from India and from abroad, in terms of what can happen in this kind of matter. But it really shows up the need for, I think, also a degree of empathy and of trying to approach these kind of matters, which may seem like just purely, oh, it's a formal matter of, oh, there's a contract and that's the end of the day. But there are bigger picture issues involved here, and that is, for instance, also one of the reasons why in their petition to the Supreme Court, the gig workers have also tried to raise the issue of Article 21, talked about the right to life and dignity. And that even though these things may fall within the realm of private enterprise, and there are certain ways in which the state can regulate it or can give certain recognition, for instance, under the Unorganized Workers Act, where you have to start looking at some of these other considerations as well, because these things aren't purely run in some fantasy commercial land where everyone's equal. Of course, as I said, we still remains to be seen exactly how all of this goes. Whether we will see an Uber-like ruling here, the way we've seen that in London and in Paris. So it's something to be kept an eye on in the future, and it's something which we have to, I think, as a society, keep in mind, given how important these services have become to us. And this again raises. There's a very interesting part of this petition in the Supreme Court where they've said that they should be recognized as frontline workers. And if you think back to the times in lockdown when they were authorized to deliver food, deliver items, which groceries, things which we've needed, these workers have been so essential to the way we've survived lockdown. They've been essential. They were already quite essential to the way our modern Indian society is, if you look at the rise of these kind of apps. So there has to be, I think, some more consideration in the way we look at them, rather than purely looking at the dry letter of the law. But even looking at the dry letter of the law, there are strong arguments that they need to be treated better.
The harsh reality of the gig economy in India is startling, and the question remains that only these platforms can answer is, at what cost are they ensuring customer satisfaction? To follow more updates regarding the story, follow the Quint's website. If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.